What's going on, y'all? What's going on, John? If you're talking about natural people, men and women, instead of actual individual is like an indivisible corporation. So, yes, the way your question is worded, corporations are governed under the same as indivisible corporations, yes, but natural men and women do not fall under the same category. Alright, so this is out of the Blackstone's Commentaries on the Laws of England. This is Book the First, Chapter 17 of Guardian and Ward. Yes. Properties and things. What's going on, Roots? So, covering Blackstone's Commentaries on the Laws of England of Guardian and Ward. Chapter 17. The only general private relation now remaining to be discussed is that of guardian and ward, which bears a very temporary parent, that is, for so long a time as the ward is an infant or under age. In examining this species of relationship, I shall first consider the different kinds of guardians, how they are appointed, and their power and duty. Next, the different ages of persons, as defined by the law, and lastly, the privileges and disabilities of an infant, or one under the age and subject to guardianship. The guardian with us performs the office both of tutor and curator of the Roman laws. The former of which had the charge of the maintenance and education of the minor, the latter the care of his fortune. Yeah, you know what I'm talking about, John. So there's two different types of guardianship. So there's the guardianship over the person, and guardianship or custodianship over the funds held in trust or in curatorship. So, yeah, or according to the language of the Court of Chancery, the tutor was the committee of the person, the curator the committee of the estate. But this office was frequently united in civil law, as it is always in our law to regard to minors, though as to lunatics and idiots, it is commonly kept distinct. Of the several species of guardians, the first are guardians by nature, the father, and in some cases the mother of the child. For if an estate be left to an infant, and the father is by common law the guardian, and must account to his child for the profits, and with regard to daughters, it seems by construction of the statute, that specific statute, that the father might by deed or will assign a guardian to any woman child under the age of 16, and if none be so assigned, the mother shall in this case be guardian. There are also guardians for nurture, which are, of course, the father or mother, till the infant attains the age of 14 years. And then in default of father or mother, the ordinary usually assigns some discreet person to take care of the infant's personal estate, and to provide for his maintenance and education. Next are guardians in socage, and appellations by the common law. These take place only when the minor is entitled to some estate and lands, and then by the common law, the guardianship devolves upon his next of kin, to whom the inheritance cannot possibly descend, as were the estate, and therefore shall be the guardian. For the law judges it improper to trust the person of an infant in his hands, who may be possibility become heir to him, and that there may be no temptation, nor even suspicion of temptation for him to abuse this trust. The Roman laws proceed on quite a contrary principle, committing the care of the minor to him who is the next to succeed to the inheritance, presuming that the next heir would take the best care of the infant, care of the estate to which he has a prospect of succeeding. But this they boast to be summa providentia. What does that mean? Huh. Don't know what that means. But in the meantime, numquam custodiae. Ah, I need to see this. What does this mean? custody of someone by right never remains with someone about whom there is suspicion that he may or may not claim any right in the inheritance itself. Wow. They forget how much it is the guardian's interest to remove the encumbrance of his pupil's life from that estate, for which he is supposed to have so great a regard. And this affords Fortescue and Sir Edward Coke an ample opportunity for triumph, they affirming that to commit the custody of an infant to him that is next in succession is quasi agnum committere lupo ad devoram dum. These guardians in soccage, like those for nurture, continue only till the minor is of 14 years of age. For then, in both cases, he is presumed to have discretion, so far as to choose his own guardian. This he may do unless one be appointed by father, by virtue of the statute which, considering the imbecility of judgment in children of the age of 14, and the abolition of guardianship in chivalry, which lasted until the age of 21, and of which we shall speak hereafter, enacts that any father under age of full age may by deed or will dispose of the custody of his child, either born or unborn, to any person, except a popish recusant, either in possession or aversion, till such child attains the age of 21 years. These are called guardians by statute, or testamentary guardians. There are all other places, but they are particular exceptions, and do not fall under the general law. The power and reciprocal duty of a guardian and ward are the same, pro tempore, as that of a father and child, and therefore I shall not repeat them, but shall only add that the guardian, when the ward comes of age, is bound to give him an account. The Roman satirist was fully aware of this danger when he puts his private prayer into the mouth of the selfish guardian. Pupillum utinam. Oh, sheesh. Let's see what this means. What's going on, Amanita? Would that I expunge the orphan whom I drive to the nearest grave. Ay, ay, ay. Sheesh. This policy of our English law is warranted by the wise institutions of Solon, who provided that no one should be another's guardian who was to enjoy the estate after his death. And Charondas, another of the Grecian legislators, directed that the inheritance should go to the father's relations, but the education of the child to the mother's, that the guardianship and right of succession may always be kept distinct. I hope everybody was paying attention to that. The policy of our English law is warranted by the wise institutions, provided that no one, directed that the inheritance should go to the father's relations, but the education of the child to the mother's, that the guardianship and right of succession might always be kept distinct. Very key point. Of all that he transacted on his behalf, and must answer for all losses by his willful default or negligence. In order, therefore, to prevent disagreeable contests with young gentlemen, it has become a practice for many guardians of large and accounting annually before the officers of that court. For the Lord Chancellor is by right derived from the crown, and the general and supreme guardian of all infants, as well as idiots and lunatics, that is, of all such persons as have not discretion enough to manage their own concerns. In case, therefore, of any guardian abuses his trust, the court will check and punish him, nay, sometimes proceed to the removal of him and appoint another in his stead. Let us next consider the ward, or person within age, for whose assistance and support these guardians are constituted by law, or who it is that is said to be within age. The ages of male and female are different for different purposes. A male at 12 years old may take the oath of allegiance. At 14 is at years old may take... Actually proved, may make his testament of his personal estate. At 17 may be an executor, and at 21 is at his own disposal, and may alien his lands, goods, and chattels. A female also of 7 years of age may be betrothed or given in marriage. At 9 is entitled to a dower. At 12 is at years of maturity, and therefore may consent or disagree to marriage, and if be proved to be sufficient discretion, to have sufficient discretion, choose a guardian. At 17 may be executrix, and at 21 may dispose of herself and her lands. So that full age in male or female is 21 years, which age is completed on the day preceding the anniversary of a person's birth, who till that time is an infant, and so styled in law. Among the ancient Greeks and Romans, women were never of age, but subject to perpetual guardianship, unless when married. Nisi covenascent in manum viri. And when that perpetual tutelage wore away in process of time, we find that in females as well as males, full age was not till 25 years. Thus, by the constitutions of different kingdoms, tutelam reponunt. What does that say? To the 21st year, and there the young men. But in Naples they were of full age at 18. In France, with regards to marriage, not till 30. And in Holland, at 20. Abilities are privileges. In order to secure them from hurting themselves by their own improvident acts, an infant cannot be feud, but under the protection and joining the name of his guardian, for he is to defend him against all attacks as well as by law as otherwise. But he may sue by his guardian, or prochain enemy. What? I don't know what that's supposed to say. His next friend, who is not his guardian. This prochain enemy may be any person who will undertake the infant's cause, and it frequently happens that an infant, by his prochain enemy, institutes a suit in equity against a fraudulent guardian. In criminal cases, an infant of the age of 14 years may be capitally punished for any capital offense, but under the age of 7 he cannot. The period between 7 and 14 is subject to much uncertainty, for the infant shall, generally speaking, be judged prima facie innocent. Yet if he was doli capax, and should discern between good and evil at the time the offense committed, he may be convicted and undergo judgment and execution of death, though he had not attained to years of puberty. Sternhub de jure Suranonen. This is also the period when the king as well as the subject arrives at full age in modern Sweden. Puberty or discretion. And Sir Matthew Hale gives us 2 instances. One of a girl of 13 who was burned for killing her mistress. Another of a boy still younger that had himself who was hanged. For it appeared by his hiding that he knew he had done wrong, and could discern between good and evil. And in such cases, the maxim of law is that... what is that? I haven't that one. With regard to estates and civil property, an infant hath many privileges, which will be better understood when we come to treat more particularly of those matters. But his may be said, nor shall any other laches, or that an infant can neither alien his lands, but still to all these rules there are some exceptions, part of which were just now mentioned in reckoning up the different capacities which they assume at different ages. And there are others, a few of which it may not be improper to recite as a general specimen of the whole. And first, it is true that infants cannot alien their estates, but infant trustees or mortgagees are enabled to convey, under the direction of the Court of Chancery or Exchequer. Oh my! I hope everyone took note of that. Also, it is generally true that an infant can do no legal acts. Yeah. Yet an infant who has an advowson may present to the benefice when it becomes void. For the law in this case dispenses with one rule, in order to maintain others of far greater consequence. It permits an infant to present a clerk who, if unfit, may be rejected by the bishop, rather than either suffer the church to be unserved till he comes of age, or permit the infant to be disbarred of his right by lapse to the bishop. An infant may also purchase lands, but his purchase is incomplete, for when he comes to age he may either agree or disagree to it, as he thinks prudent and proper, without alleging any reason. And so may his heirs after him, if he dies without having completed his agreement. Yes, they do. That's why we're judged. For 7 years. And he may by deed or will appoint a guardian to his children if he has any. Lastly, meat, drink, apparel, physic, and such other necessaries, and likewise for his good teaching and instruction, whereby he may profit himself afterwards. And thus much at present for the privileges and disabilities of infants. So that's on guardians and ward, curators and tutors.
There she is.
I'm curious, but what's going on? This is on Blackstone's of Title by Bankruptcy. The preceding chapter, having treated pretty largely of the acquisition of personal property by several commercial methods. Yeah, all law comes from equity is the soul and then spirit of the law. What is right? What is equitable? What is fair? Everything is based on the scales, the universal scales of judgment, scales of equity. And that's what people call karmic scales. People call them, karma or other things like that. It's just like it's the scales of judgment. So, but yeah, the equity is the spirit that measures and weighs out one thing against another, whether they be equal or whether it be fair. So that's not Lady Justice, that's Themis. That idol that they keep making, that's not justice. Don't be fooled. That thing is not justice, that's Themis. It's a false god. That's why the scales are always unjust. They're always lopsided. And they do exactly that. So alright, acquisitions. We from thence shall be easily led to take into our present consideration a 10th method of transferring property, which is that of bankruptcy, a title which we before lightly touched upon, so far as it related to the transfer of real estate of the bankrupt. A bit more minutely, as it principally relates to the disposition of chattels, in which the property of persons concerned in trade more usually consists than in lands or tenements. Let us therefore first of all consider who may become a bankrupt, what acts make a bankrupt, the proceedings on a commission of a bankrupt, and in what manner an estate in goods and chattels may be transferred by bankruptcy. Who may become bankrupt? A bankrupt was before defined to be a trader who secretes himself or does certain other acts tending to defraud his creditors. He was formerly considered merely in the light of a criminal or offender, and in this spirit we are told by Sir Edward Coke that we have all fetched as well as the name as the wickedness of bankrupts from foreign nations. But at the present laws of bankruptcy are considered as laws calculated for the benefit of trade, and founded on the principles of humanity as well as justice, and to that end we confer some privileges not only on his creditors but also on the bankrupt or debtor himself. On the creditors, by compelling the bankrupt to give up all his effects to their use without any fraudulent concealment. On the debtor, by exempting him from the rigor of the general law, whereby his person might be confined at the discretion of his creditor, though in reality he has nothing to satisfy the debt. Whereas the law of bankrupts, taking into consideration the sudden and unavoidable accidents to which men in trade are liable, has given them the liberty of their persons and some pecuniary emoluments, upon condition they surrender up their whole estate to be divided among their creditors. Yeesh. In this respect, our legislature seems to have attended to the example of the Roman law. I mean not the terrible law of the 12 tables, whereby the creditors might cut up the debtor's body into pieces, and each of them take his apportionable share, if indeed that law, de debitore in partes fecando, is to be understood in so very butcherly a light, which many learned men have with reason doubted. This title can be interpreted in two ways. Some people believe it means literally cut a debtor into pieces. Removing all torture. Okay. And it was said that DQ's move. Oh, it has it in the Black's Law? Of cutting a debtor into pieces. 12 tables. The meaning of which has occasioned much controversy. Some commentators have concluded that it was literally the privilege of the creditors of an insolvent debtor, all other means failing, to cut his body into pieces and distribute it amongst them. Others contend that the language of this law must be taken figuratively, denoting a cutting up and apportionment of the debtor's estate. The latter view has been adopted by Montesquieu, oh man, I can't pronounce that. Esprit de Louis. Sheesh. Yeah, they were cutting people to pieces. Alright, is to be understood in so butcherly a light, which many learned men with reason doubted. Nor do I mean those less inhuman laws, if they may be called so, as their meaning is indisputably certain, of imprisoning the debtor's person in chains, subjecting him to stripes and hard labor at the mercy of Trans-Tiberium, across the Tiberias River, an oppression which produced so many popular insurrections and secessions to the mons facere. But I mean the law of cession, introduced by the Christian emperors, whereby if a debtor ceded or yielded up all his fortune to his creditors, he was secured from being dragged into a gaol, omni quoque corporali cruciatos moto. What's going on? Let's see. Alright. See what it says. Come on now. Wow, they don't want to pick it up. Also, all bodily torment removed. For as the emperor justly observes, oh shoot, it just depends. First 30, when consultations, I don't charge for the first 30 minutes because I can't guarantee that I can take on any certain thing. So I usually listen to it. But like I said, hit me. Send me a message on my website, fill out my contact form and then put your number in there. If you want me to just respond somewhat it's not super time consuming, you can just put your email, but if you really want to get a hold of me, put your number down and all that. But generally after 30 minutes I charge $75 per hour, just with like 1 hour minimums. Just like I said, I do have a lot going on, and on myself I'm getting out too. So, but that's generally my fee schedule on that. But, let me see. Fortunis suis spoliatum. There we go. It is inhumane to be condemned to a life of misery, robbed of one's fortune. Hoo-hoo-y. Starting from one extreme is apt to produce its opposite. We find it afterwards enacted that if the debtor, by any unforeseen accident, was reduced to low circumstances, and would swear that he had not sufficient left to pay his debts, he should not be compelled to cede or give up even that which he had in his possession. A law which, under a false notion of humanity, seems to be fertile of perjury, injustice, and absurdity. It's on a lot of my last posts. Want to set up a trust? I do have a trust package that I set up for like $500, just because it takes me a while to set it up. And I prepare the paperwork, and then you still have to execute it. But I do that. So I do a few other things as well. So I do. If you need to get a name change done, I assist with that. If you need to get other things, we just take it on a case-by-case basis. I won't. Like I said, just hit me up. So, if you got something else going on, mortgages, I don't have like haven't done them yet. Although I have been working on this one case with the mortgage. I'm still waiting on to see what happens with that. And I have handled a few different child support matters, and I've annulled my own marriage license. So I've done a few different things. So if you need my assistance, send me a message and we'll work it out. Where did it say that? Well, hold on. Sufficient to pay his debts. Okay. The laws of England, more wisely, have steered in the middle between both extremes, providing at once against the inhumanity of the creditor, which is not suffered to confine an honest bankrupt after his effects are delivered up, and at the same time taking care that his just debts shall be paid, for as far as the effects will extend. But still they are cautious of encouraging prodigality and extravagance by this indulgence to debtors, and therefore they will allow the benefit of the laws of bankruptcy to none but actual traders, since that set of men are, generally speaking, the only persons liable to accidental losses and to an inability of paying their debts without any fault of their own. If persons in other situations of life run in debt without the power of payment, they must take the consequences of their own indiscretion, even though they meet with practice for any person but a tradesman to one in liberal possession at the time of contracting his debts has a sufficient fund to pay them. The delay of the payment is a species of dishonesty and a temporary injustice to his creditor. And if at such time he has no sufficient fund, he cannot therefore murmur if he suffers the punishment which he has voluntarily drawn upon himself. But in mercantile transactions, the case is far otherwise. Trade cannot be carried on without mutual credit on both sides. The contracting of debts is therefore here not only justifiable but necessary. And if by accidental calamities, as of the loss of a ship in the tempest, the failure of brother traders, or by the non-payment of persons out of trade, a merchant or tradesman becomes incapable of discharging his own debts, it is his misfortune and not his fault. To misfortunes, therefore, of their faults, since at the same time that it provides for the security of commerce, by enacting that every considerable trader may be declared bankrupt, for the benefit of his creditors, as well as himself, It is also to discourage extravagance declared that no one shall be capable of being made a bankrupt, but only a trader, nor capable of receiving the full benefit of the statutes, but only an industrious trader. The first statute made concerning any English bankrupts was 32nd Henry. And then when trade began first to be properly cultivated in England, which has been almost totally altered by Statute 13 of Elizabeth, whereby bankruptcy is confined to such persons as have used the trade of merchandise in gross or by retail, by way of bargaining, exchange, rechange, bartering, chevisance, or otherwise, or have sought their living by buying and selling, and by Statute 21 of so and so persons using the trade or possession of a survivor, receiving other men's monies and estates into their trust and custody, are also made liable to the statutes of bankruptcy. And the benefits as well as the penal parts of the law are extended as well to aliens and denizens as to natural born subjects, being intended entirely for the protection of trade, in which aliens are often deeply concerned as natives. By many subsequent statutes, by Statute 5 of George II, bankers, brokers, and factors are declared liable to the statutes of bankruptcy, and this upon the same reason that scriveners are included by the statute of James I, viz., for the relief of their creditors, whom they have otherwise more opportunities of defrauding than any other set of dealers, and they are properly to be looked on as traders, since they make merchandise of money in the same manner as other merchants do of goods and other movable chattels. But by the same act, no farmer, grazier, or drover shall as such be liable to be deemed bankrupt, for though they buy and sell corn and hay and beasts in the course of husbandry, yet trade is not their principal, but only a collateral, its produce. And besides, the subjecting of them to the laws of bankruptcy might be a means of defeating their reserved rents. Wherefore also, upon a similar reason, a receiver of the king's taxes is not capable, as such, of being bankrupt, lest the king should be defeated of those extensive remedies against his debtors, which are put into the hands of the prerogative. By the same statute, no person shall have commission of a bankrupt awarded against him, unless at the petition of some one creditor to one who owes him 100, or of two, to whom he is indebted 150 L or more, to whom altogether he is indebted to 200 L. For the law does not look upon persons whose debts amount to less to be trader or mercer, in one general word, a chapman, who is one that buys and sells anything, but no handicraft occupation, where nothing is bought and sold, and therefore an extensive credit for the stock in trade is necessary to be had, will make a man a regular bankrupt, as that of a husbandman, a gardener, and the like, who are paid for their work and labor. Also, an innkeeper cannot, as such, be a bankrupt, for his gain or livelihood does not arise from buying and selling in the way of merchandise, but greatly from the use of his rooms and furniture, his attendants, and the like. And though he may buy corn and victuals to sell again at a profit, yet that no more makes him a trader than a schoolmaster or other person is that keeps a boarding house and makes considerable in the house, and such a one is clearly not within the statutes. But where persons buy goods and make them up into saleable commodities, as shoemakers, smiths, and the like, here, though the part of the gain is by bodily labor, and not by buying and selling, yet they are within the statutes of bankrupts, for labor is only an amelioration of the commodity, and rendering it more fit for sale. One single act of buying and selling will not make a man a trader, but repeated practice and profit by it. Buying and selling bank stock or other government securities will not make a man bankrupt, but they not being goods, wares, or merchandise, within the intent of the statute, by which a profit may be fairly made. neither will buying and selling under particular restraints or other particular purposes as if a commissioner of navy uses to buy victual and refuse. He is not thereby made a trader within the statute. Cannot be made bankrupt, for an infant can owe nothing but for necessaries, and the statutes of bankruptcy create no new debts, but only give a speedier and more effectual remedy for recovering such as were before due. And no person can be made a bankrupt for debts, which he is not liable at law to pay. But a feme covert in London, being a sole trader according to the custom, is liable to a commission of bankrupt. Having thus considered who may and who may not be made a bankrupt, we are to inquire, secondly, by what acts a man may become a bankrupt. A bankrupt is a trader who secretes himself or does certain other acts tending to defraud his creditors. We have hitherto been employed in explaining the former part of the description, a trader. Let us now attend to the latter, who secretes himself or does certain other acts tending to defraud his creditors. And in general, whenever such a trader, as is before described, hath endeavored to avoid his creditors or evade their just demands, this hath been declared by the legislature to be an act of bankruptcy, upon which a commission may be sued out. For in this extrajudicial method of proceeding, which is allowed merely for the benefit of commerce, the law is extremely watchful to detect a man whose circumstances are declining, in the first instance, or at the least as early as possible, that the creditors may receive a large proportion of their debts as may be, and that a man may not wantonly wasting his substance then claim the benefit of the man bankrupt. We must consult the several statutes and resolutions formed, therefore be reckoned, departing from the realm whereby a man would from the jurisdiction attempt to defraud his creditors, procuring his money, goods, chattels, and effects to be attached or sequestered by any legal process, which is another plain and direct endeavor to disappoint his creditors of their security. His goods and chattels, which protection not being himself pledged by Parliament, in order to screen his person, endeavoring or desiring by any petition to the king, or bill exhibited in any of the king's courts against any creditors, to compel them to take less than their just debts, or to procure, lying in prison for 2 months or more upon arrest or other detention for debt without finding bail in order to obtain his liberty. For the inability to procure bail argues a strong deficiency in his credit, owing either to his suspected poverty or ill character, and his neglect to do it, if able, can arise only from a fraudulent intention, in either of which cases is a high time for his creditors to look themselves and compel a distribution of his effects, or upwards. Let me see what's going on. For no man would break prison that was able and desirous to procure bail, which brings it within the reason of the last case, neglecting to make satisfaction for a just debt to the amount of £100 within 2 months after service or leave of acts of bankruptcy expressly defined by the statutes relating to this title, which being so numerous, and the whole law of bankrupts being an innovation on the common law, our courts of justice have been tendered so extending or multiplying acts of bankruptcy by any construction or implication. And therefore Sir John Holt held that a man's removing his goods privately to prevent their being seized in execution was no act of bankruptcy, for the statutes mention only fraudulent gifts to third persons, and procuring them to be seized by sham process in order to defraud creditors. But this, though a palpable fraud, yet falling within neither of those cases, cannot be adjudged an act of bankruptcy. So also it has been determined expressly that a banker's stopping or refusing payment is no act of bankruptcy, for it is not within the description of any of these statutes, and there may be good reasons for his doing, as suspicion of forgery and the like, and in consequence of such refusal he is arrested and puts in bail. Still, it is not act of bankruptcy, But if he goes to prison and lies there 2 months, then and not before is he become bankrupt. We have seen who may be a bankrupt, and what acts will make him so. Let us next consider the proceedings on a commission of a bankrupt, so far as they affect the bankrupt himself, and these depend entirely on the several statutes of bankruptcy, all which shall endeavor to blend together and digest into a concise methodical order. And first there must be a petition to the Lord Chancellor by one creditor of the amount of 100 L, or to the amount of 100 L, or by... What is this method of currency? That was it. It's British pounds. Oh, so it is pounds. Okay. Pounds. Okay. 150 pounds. Or 3 or more to the amount of 200 pounds, upon which he grants a commission to such discreet persons as to him shall seem good, who are then styled commissioners of bankrupt. The petitioners, to prevent malicious applications, must be bound in a security of 200 pounds, to make the party amends in case they do not prove him a bankrupt. And if, on the other hand, they receive any money or the effects of it from the bankrupt as a recompense for suing out the commission, so as to receive more than their rateable dividends of the bankrupt's estate, they forfeit not only what they shall have so received, but their whole debt. These provisions are made as well to secure persons in good credit from being damnified by malicious petitions, as to prevent knavish combinations between creditors and the bankrupt, in order to obtain the benefit of commission. When the commission is awarded and issued, take an oath for the due execution of their commission, per diem each at every sitting. And no commission of a bankrupt shall abate or be void upon any devise of the crown. That sounds good. It's good. Alright, let me see. The pound symbol is that, and its ISO code is GBP. Okay, the pound sterling is the official currency. The UK, okay, South Georgia. Yes, what is a shilling? Okay, that's good to know. Quid. Pence. Does S stand for shillings, though? Come on now. 20 shilling per diem at each sitting. Okay. When the commissioners have received their commission, they are first to revive proof of the person's being a traitor and being committed to some act of bankruptcy, and then to declare him a bankrupt, if proved so, and to give notice thereof in the Gazette, and at the same time to appoint 3 meetings. At the first of these meetings, an election must be made of the assignees, or persons to whom the bankrupt's estate shall be assigned, and in whom it shall be vested for the benefit of the creditors, which assignees are to be first named by the commissioners, and afterwards to be approved or rejected at the said meeting by the major part in value of the creditors, who shall then prove their debts. So this is why assignment of interest works, because everybody's considered bankrupt. Good to know. Alright. But no creditor shall be admitted to vote in the choice of assignees. That's what it means. Okay. Libra. I was gonna say, why is it L? Shall not amount to £10. At the second meeting, any farther business relating to the commission may be proceeded on. Wait, no, I already talked about the abode. Okay. In case the bankrupt abscond, run off with some type of property between the time of the commission issued and the last day of surrender, they may by warrant from any judge or justice of the peace be committed to the county gaol in order to be forthcoming to the commissioners, who are also empowered immediately to examine him touching all matters relating to his trade and effects. They may also summon before them and examine the bankrupt's wife and other person whatsoever as to all matters relating to the bankrupt's affairs, and in case any of them shall refuse to answer or shall not answer fully any lawful question, or shall refuse to subscribe such their examination, the commissioners may commit them to prison without bail, till they make and sign a full answer, the commissioners specifying in their warrant of commitment the question so refused to be answered, and any gaoler permitting such persons to escape or go out of prison shall forfeit £500 to the creditors. Whoa. The gaoler. So that's where these games get their names. The goalie on soccer. Wow. Bankrupt upon this examination is bound upon pain of death to make opposed of the same, together with all books and writings relating thereto, and is to deliver up all in his own power to the commissioners, except the necessary apparel of himself, his wife, and his children, or in case he conceals or embezzles any effects to the amount of £20, or withholds any books or writings with intent to defraud his creditors, he shall be guilty of a felony without benefit of clergy. After the time allowed to the bankrupt for such discovery is expired, any other person voluntarily discovering any part of his estate before unknown to the assignees shall be entitled to 5% out of the effects so discovered, and such further reward as the assignees and commissioners shall think proper. And any trustee willfully concealing the estate of any bankrupt, after the expiration of 2 and 40 days, shall forfeit £100, and double the value of the estate concealed to the creditors. Hitherto, everything is in favor of the creditors, and the law seems to be pretty rigid and severe against the bankrupt. But in case he proves honest, it makes him full amends for all this rigor and severity. For the bankrupt hath made an ingenious discovery, hath conformed to the directions of the law, and have acted in all points to the satisfaction of his creditors. And if they, or 4 parts, and 5 of them in number and value, but none of them creditors for less than 20 pounds, will sign a certificate to that purport. The commissioners are then to authenticate such a certificate under their hands and seals, and to transmit it to the Lord Chancellor, and he or 2 judges, whom he shall appoint on oath made by the bankrupt, that such certificate was obtained without fraud, may allow the same or disallow it upon cause shown by any of the creditors of the bankrupt. If no cause be shown to the contrary, the certificate is allowed, of course, and then the bankrupt is entitled to a decent and reasonable allowance out of his effects, for his future support and maintenance, and to put him in a way of honest industry. This allowance is also in proportion of his former good behavior in the early discovery of the decline of his affairs, and thereby giving his creditors a larger dividend. For if his effects will not pay 1/2 of his debts, to have a competent sum allowed him, not exceeding 3%. But if they pay 10 shillings in the pound, he is to be allowed 5%. If 12 shillings and 6 pence, then 7.5%. And if 15 shillings in the pound, then the bankrupt shall be allowed 10%, provided that such allowance do not in the first case exceed 200 pounds, in the second 250 pounds, and in the third 300 pounds. Besides this allowance, he has also an indemnity granted him of being free and discharged forever from all debts owing by him at the time he became bankrupt, even though judgment shall have been obtained against him, and he lies in prison upon execution for such debts. And for that, among other purposes, all proceedings on commissions of bankrupt are on petition to be entered of record, as a perpetual bar against actions to be commenced on this account, though in general the production of the certificate, if properly allowed, shall be sufficient evidence of all previous proceedings. Jail. Go. That's a wild way to spell jail. They misspelled it as gold now. Thus the bankrupt becomes a clear man again, and by the assistance of his allowance and his own industry may become a useful member of the Commonwealth, which is rather to be expected, as he cannot be entitled to these benefits but by the testimony of his creditors themselves of his honest and ingenuous disposition, unless his failures have been owing to misfortunes rather than to misconduct and extravagance. For no allowance or indemnity shall be given to a bankrupt, unless his certificate be signed and allowed as before mentioned, and also if any creditor produces a fictitious debt, and the bankrupt does not make discovery of it, but suffers the fair creditors to be imposed upon, he lose all title to these advantages. Neither can he claim them if he has given with any of his children above 100 pounds for a marriage portion, unless he had at the time sufficient left to pay all his debts. For if he has lost at any one time 5 pounds, or in the whole 100 pounds, within a 12-month before he became bankrupt, by any manner of gaming or wagering whatsoever, or within the same time he has lost to the value of 100 pounds by stock jobbing. Also, to prevent the too common practice of frequent and fraudulent and careless breaking, a mark is set upon such as have been once cleared by a commission of bankrupt, or have compounded with their creditors, or have been delivered by an act of insolvency, which is an occasional act frequently passed by the legislature, whereby all persons whatsoever who are either in too low a way of dealing to become bankrupts, or not being in a mercantile state of life, are not included within the laws of bankruptcy, are discharged from all suits and imprisonment upon delivering up all their estate and effects to their creditors upon oath at the sessions or assizes, in which case their perjury or fraud is usually, as in the case of bankrupts, punished with death. Persons who have been once cleared by this, or either of the other methods of composition with their creditors or bankruptcy, and afterwards become bankrupts again, unless they pay full 15 shillings in the pound, are only thereby indemnified as to the confinement of their bodies, but any future estate they shall acquire remains liable to their creditors, excepting their necessary apparel, household goods, and the tools and implements of their trades. Thus much for the proceedings on a commission of bankrupt, so far as they affect the bankrupt himself personally. Let us next consider how such proceedings, the method whereby a real estate in lands, tenements, and hereditaments may be transferred by bankruptcy, was shown under its proper head in a former chapter. At present, therefore, we are only to consider the transfer of things personal by this operation of law. By virtue of the statutes before mentioned, all personal estate and effects of the bankrupt are considered as vested by the act of bankruptcy in the future assignees of his commissioners, whether they be goods in actual possessions, or debts, contracts, or other choses in action, and the commissioner by their warrant may cause any house or tenement of the bankrupt to be broken open, in order to enter upon then seize the same. And when the assignees are chosen or approved by the creditors, the commissioners are to assign everything over to them, and the property of every part of the estate is thereby as fully vested in them as if it was in the bankrupt himself, and they have the same remedies to recover it. The property vested in the assignees is the whole that the bankrupt had in himself at the time he committed the first act of bankruptcy, or that has been vested in him since, before his debts were satisfied or agreed for. Therefore, it is usually said that once a bankrupt and always a bankrupt, by which is meant that a plain direct act of bankruptcy once committed cannot be purged or explained away by any subsequent conduct, as a dubious equivocal act may be, but that if a commission is after reference back to the first and original act of bankruptcy, insomuch that all transactions of the bankrupt are from that time absolutely null and void, either with regard to the alienation of his property or the receipt of his debts from such as are privy to his bankruptcy. For they are no longer his property or his debts, but those of the future assignees. Oh! I hope everyone read that right. Okay, I'm going to read that again. Insomuch that all transactions of the bankrupt are from that time absolutely null and void, either with regard to the alienation of his property or the receipt of his debts from such as are privy to his bankruptcy, for they are no longer his property or his debts, but those of the future assignees. And if an execution be sued out, so you have two processes in judgment. You have a declaratory judgment or declaratory relief granted, and changing the status of the parties. Now, let's just say that's for a sum of money to be owed. They're stating that debtor is in arrears. Only upon a writ of execution generally can it be, seized or taken possession of. Let me see. If an execution be sued out, but not served and executed on the bankrupt's effects till after the act of bankruptcy, it is void, as against the assignees. But the king is not bound by this fictitious relation, nor is within the statutes of bankrupts. For if, after the act of bankruptcy committed, and before the assignment of his effects, an extant issues for the debt of the crown, the goods are bound thereby. In France, this doctrine of relation is carried to a very great length, for there every act of a merchant, for 10 days precedent to the act of bankruptcy, is presumed to be fraudulent and is thereby void. But with us, the law stands upon a more reasonable footing, for as these acts of bankruptcy may sometimes by secret to all but a few, and it would be prejudicial to trade to carry this notion to its utmost length, it is provided by Statute 19 of George II that no money paid by a bankrupt to a bona fide or real creditor in a course of trade, even of so-and-so, shall any debtor of a bankrupt that pays him his debt without knowing his bankruptcy be liable to account for it again. The intention of this relative power being only to reach fraudulent transactions, and not to distress the fair trader. Yeah. Bankrupts are considered fictions in law because they have a legal fiction. The assignees may pursue any legal method of recovering his property so vested in them by their own authority, but cannot commence a suit in equity, nor compound any debts owing to the bankrupt, nor refer any matters to arbitration without the consent of the creditors, or the major part of them in value, at a meeting to be held in pursuance of notice in the Gazette. Well, that's wild. That's why there's no more courts of equity, because everybody's bankrupt. When they have got in all the effects they can reasonably hope for and reduce them to ready money, the assignees must, within 12 months after the commission issued, give 1 and 20 days notice to the creditors of a meeting for a dividend or distribution, at which time they must produce their accounts and verify them upon oath if required. And then the commissioners shall direct a dividend to be made at so much in the pound to all creditors who have before proved or shall then prove their debts. This dividend must be made equally and in a ratable portion to all the creditors according to the quantity of their debts, no regard being had to the quality of them. Mortgages, indeed, for which the creditor has real security in his own hands, are entirely safe, for the commission of a bankrupt reaches only the equity of redemption. So are also personal debts, where the creditor has a chattel in his hands, as a pledge or pawn for repayment, or has taken the debtor's lands or goods in execution, and upon the equity of that statute, 8th of Anne, which directs that upon all executions of goods being on any premises demised to a tenant, 1 year's rent and no more shall, if due, be paid to the landlord. It hath also been held that under a commission of a bankrupt, which is in the nature of a statute execution, the landlord shall be allowed his arrears of rent to the same amount in preference to other creditors, even though he had neglected to distrain, while the goods remained on the premises, while he is otherwise entitled to do for his entire rent, be the quantum what it may. Because a lot of these corporations are owned by the British Crown. That's why. The Gazette, I think, is the paper. I'm not sure exactly which Gazette they're talking about, but yeah. The reason why people are in debt right now and everybody's always been under British law is because it's been British corporations. But otherwise, judgments and recognizances, both which are debts of record, and therefore at other times have a priority, and also bonds and obligations by deed or special instrument, which are called debts by specialty, and are usually the next in order. These are all put on a level with debts by mere simple contract, and all paid pari passu, nay, so far in the matter, nay, some of the dividend made, as bonds or notes of hand payable at a future day, shall be paid equally with the rest, allowing a discount or drawback in proportion. Ho ho! Okay. Yo. Yep. That was wild. So far as the matter is carried that the express provision of statutes, debts not due at the time of the dividend made, as bonds or notes of hand payable at a future day, shall be paid equally with the rest, allowing a discount or drawback in proportion. Wow. And insurances and obligations upon bottomry or respondentia bona fide made by the bankrupt, though forfeited after the commission is awarded, shall be looked upon in the same light as debts contracted before any act of bankruptcy. Oh, what did I say about the IRS being owned by Northern Trust Company or Northern Trust Corporation? One of the, I gotta look up the name, exact name every time. But yeah, the IRS is a private organization. Within 18 months after the commission issued, a second and final dividend shall be made unless all effects were exhausted by the first, and if any surplus remains after paying every creditor his debt, every creditor. This is a case which sometimes happens to men in trade who involuntarily or at least unwarily commit acts of bankruptcy by absconding and the like, while their effects are more than sufficient to pay their creditors. And if any suspicious or malevolent creditor will take advantage of such acts and sue out a commission, the bankrupt the effects of his own imprudence, except that upon satisfaction made to all the creditors, the commission may be superseded. This case may also happen when a knave is desirous of defrauding his creditors, and is compelled by a commission to do them that justice, which otherwise he wanted to evade. And therefore, though the usual rule is that all interest on debts carrying interest shall cease from the time of issuing the commission, yet in the case of a surplus left after payment of every debt, such interest shall again revive and be chargeable on the bankrupt or his representatives. So, I hope that was insightful. That was a lot. I keep telling everyone, England's laws affect America to this day. The old world England in America affects the new world here in America. So that is definitely something there. That's why they have assignment of interest, assigning future interest and wages, because the debtor is bankrupt. And then you have a discount or a drawback, which is why they did the chargebacks from the Edward Mendel House quote, and then stuff like that. So they're very clearly showing how bankruptcy law is still according to the laws of England and Great Britain here in America. So the old United Kingdom, Britannia here in America, passed on its laws to the estates, the 13 estates, 13 bloodlines, 13 Federal Reserve districts. So 13 stars and stripes. So yeah, it all got passed down. Any comments on that so far? Any questions? Let me know. So I'll probably go another 20-30 minutes. So, yeah, everyone here is bankrupt. HJR 192, Public Law 73-10. Yeah. Yeah. Are you talking about the process, like execution, judgment, and execution? Well, dealing with persons, you have a declaratory judgment, a declaratory relief sought out and obtained. So let's say that someone owed you 200 pounds, or 500 pounds rather, and you sue them out for, declaratory judgment stating that they owed you 500 pounds or the equivalent in currency, and you got the judgment. That is a declaratory judgment. So now, because all that does is state that creates a presumption now that they're essentially, it's been found that yes, they actually do owe you XYZ amount. From what the point on, it's dependent upon the debtor, the judgment debtor, because now they have to either account for it and give you the 500 pounds, or they have, they might abscond with it or something else, or to try to defraud you. So then it becomes in dealings with execution, especially writs of execution. A writ of execution, such as a fieri facias, is essentially an ancient writ that wherever the debtor may be found, his goods and properties, his goods and chattels are able to be seized. What we know of is how it was seized by the sheriff. Now, sheriff, I'm pretty sure it's an office granted by the, I think of Queen Elizabeth, if I'm not mistaken, because it's Sharif, it's Islamic, or I don't know, Ishmaelite or something like that, but middle, Japhetic, some type of either Shemitic or Japhetic, but they would apply for a writ of you would apply for a writ of execution. The sheriff would serve the writ of execution, and upon the writ would seize the goods and chattels, and then upon seizing the goods and chattels would return them to either court. They'd either be sold or conveyed over to you for livery and season. That is the process. It's a two-part process of getting declaratory judgment, which declares that one is in arrears, and the second part, which actually seizes the property or thing. Which is why you have to go to courts, spiritual and temporal, and do different methods in both. So, hope that answers your question. So that's what it's talking about. Most people, aren't used to having to do too much because the courts pay out a lot of stuff, but because of the court's chancery and the courts, courts at law, at common law, there was a difference. So that was an excellent question, though. So yeah, same thing we got today because of the ongoing bankruptcies. You have OIDs, or original issue discounts, a discount or drawback on the property from the dividends of the bankrupt estates held in receivership or custodianship by the commissioners. Then you have, from that point, you have the OIDs, the drawbacks, the assignment of interest for the future assignment of future wages or future interests and proceeds, etc. Yeah, absolutely, Roots. So that's something there. Those are very key terms. People don't like. It was all because of the original operations in British law. And without understanding those original operations, you won't see what's going on today. So, this is why I'm covering Blackstones on Thursdays, because, the Constitution does not apply. Hamilton versus Eaton, 1796, declared that the treaty, under the supremacy clause of the original Constitution at that time, then adopted in North Carolina previously, declared that any state, and all judges are bound to enforce the Treaty of Paris 1783 as supreme to any domestic policy, superseding the Constitution and all of its effects. And though it's a North Carolina case, the way he wrote it, it was more of an acknowledgement than it needed to, than just necessarily a binding precedent, but it imposed the same, and it doesn't apply to everyone, because most people go under domestic affairs. Domestic affairs will get you killed. That's why they have domestic violence. So, like Boris said, you either know international law or you're dead in the water. So, international law is the law of conveyancing and the law of trusts, the law of feuds, feudal tenures, estates, and fee simple, fee tail, all that. So, those are the things that you have to pay attention to. Who holds the title to the estate? Who holds an interest in the estate? Who holds a certain, who is exercising a right or claiming a right? Who is operating on behalf of someone else? And what is their goal or their motive? So yeah. This is why you can't be a bankrupt person. Yeah, adhesion contract. Well, it's more than just an adhesion. Well, I don't know what you're talking about quite with reference to the adhesion contract, but yeah. So everyone is considered. How can I find Boris? I think it's Boris. Some of his YouTube stuff is still up, but he's on Rumble. It's Law of Boris. Yeah, his stuff is up there on Rumble. So I don't know if you can check out who I'm following on Rumble. I think I'm following him. It's got like a little guy in a black hat and a red background, little cartoon looking character. The cartoon character almost looks like a thief or something like that, or he's like grinning kind of crazy. But if you type in Law of Boris, I think it pops up. But he understands international law, so I didn't know that. I listened to some of his stuff, but I had to make sense of other things in combination with Christian Walters. I had to relate everything to trust, and so once I understood that, it was different. So yeah, the way that everything is operated now, it's all because of bankruptcy. And the only way to end the insolvency is to essentially take the assets out of receivership by right of remainder. So yeah, Boris, he knew a good bit. He was on a lot of people's stuff. He knew quite a bit about international law and endorsements. Still does. And I heard him talking several times about the Geneva Convention, so I know he was talking about that as well. Christian Walters. I learned the most about trust from Christian Walters. I listened to a good number of his videos and his content from like 2009 to 2011 time frame. Didn't have access to everything at that time, but what I did have access to, I studied and studied and studied and studied. I didn't, I just listened to the audios over and over and took notes and rewound it, played it on repeat. I did a lot. But Christian Walters was one of the top authorities on trust I've ever found. And he was reading directly from source material all the time. So, that's why I liked what he talked about. So I haven't heard anyone quite in the same manner talk about trusts, or to any of the same degree. I heard David Clarence talk a little bit about estates, but not about conveyancing of estates. He wanted to change the situs, but that was all he mentioned. I stuck mainly to, like, I took a lot from what Boris said. Boris was pretty influential because treaty law is international contract law, just on a high contracting power scale, or a national signatory level. So that's one thing that really does, it really helps, because the treaty, and a treaty regarding foreign policy is considered the last expression of the public will, meaning it supersedes anything that goes on in domestic affairs, and it's under the original supremacy clause and all that. Yeah, I don't know if I watched that many. It's been, a lot of this stuff wasn't actually on archives at the time. Now it is. I don't know when they got uploaded, but I listened to a good number of them, 20 or 30 of them at least. And I mean, I listened to them like a bunch. So that's how I found out a lot of stuff. How to administer the trust, how to set up the tax formation or the tax recognition of the trust. That's how I found out about things like how to fill out W-8 bins and stuff like that. That's how I found out about a lot of stuff. Right, and he just straight up went to the man and the instructions for the forms. It's where anyone should look. Yeah, that's good. Okay, so sheriff, yeah. I knew it was a British position, which is why they know what's going on. So, yeah. Conveyancing, it's all under bankruptcy law, international law, trust law, and estate law, and conveyancing. And that's like the majority of most things in the public right now. So yeah, there's a bunch of stuff like that. Gene Keating was good, but he was doing a lot of processes that were like very, very technical. Very, very technical. So if you don't know exactly what you're doing, he'll get you confused. So, yeah. I know, it does. It really does take a long time for comments. Yeah. Well, I know that. Yeah, I did the SSA 521. It'll shut stuff off if you're not prepared for it. So if you're like receiving SSI or something like that, then it might be like you have to make sure that you plan accordingly. But I had some stuff change when that happened. But yeah, I did do the SSA 521. Yep. I'm just thinking, who else was good? There were a few people that were good. Yeah. Yeah, I mean, if anything, I'm just reading the instructions. That's it. The instructions will tell you what to do. So, a lot of time, like, and honestly, most things are really just in the instructions. Like, you just read the instructions, and it's like it has some kind of crazy thing that nobody finds, and it's just like, yeah, most people aren't gonna see that. Yeah, the Treaty of Paris, 1783, was the treaty that purportedly ended the Revolutionary War, and because it was signed by the Continental Congress under the Articles of Confederation, it does still apply. Yeah, that's good though. That's good that you're in there with that changing the name. Yeah, Paris Peace Treaty is legitimate. It's yeah, they both, the Treaty of Paris 1763 and 1783. 1763 stopped the French Indian War, I believe it was the French Indian War, and then 1783 stopped the Revolutionary War. And then it talked about how the King of France, the Christian crown or something like that, or King of Great Britain and France, was the elector and arch-treasurer of the Holy Roman Empire. Which most people probably didn't catch. So, he, I believe, was a plenipotentiary at that time. Yep. Okay, that works. Absolutely. Yeah, and I know this BOI thing is back and forth, but I would still not leave your assets unprotected either way. So, yep. So, yeah, for things to study, like study tax law, study trust law, estate law, conveyancing, bankruptcy. Understand like the key principles. You don't have to be an expert in everything, but if you understand the basic principles at a fundamental level, you'll start seeing how they play out in larger scales with just about everything, because of the way that estates are settled. So a settlement of estates and things like that, customary practice, understanding just the basic principles of what happens in import and export, why excise taxes are levied. So those are the things that really help understand, because they really do make a difference. And the maxims tell you how it operates as well. The maxims will tell you, the what has happened through the course of time, because there had to be a large precedent enough to warrant a maxim being created that is generally true. So it may not be all cases, but as long as it applies to the case, it is generally true. Which means it doesn't have to be proved, because you're dealing with, in the courts, you're dealing with import of evidence. That's why they say importance of evidence. So it has to follow the rules of evidence. Ooh, that's good. Yeah, let me know. Yeah, excise taxes. Big key right there. Big key. Yeah. So that's what people are really paying, these days. So yeah, Christian Walters was real good with trusts. Carlton Weiss was real good with trusts. Yeah. Excise tax, yeah, it's not supposed to. The way that they did things was crazy. They tried to take all the benefit, but it's under the articles of the Geneva Convention. The Geneva Convention. Why else does certain things have, happen out of Switzerland? Like, certain organizations trying to mandate certain things with, carbon zero. Why are, you having, so many things happen, with POW, MIA, like stuff like that. So it's all because of the Geneva Conventions. All of it. So, any last questions for the night? Let me know. So, like I said, if you want to set up a consultation, if you have my number, hit me up. If you don't already have my number, just like I said, put your number in my contact form, email, name, what you're looking to do, and I'll get with you as soon as I'm able to. So, if you want to set up a trust, let me know. If you want to, set up a consultation, let me know as well. If you want to join the group and you're not a part of the group already, let me know that too. It is $200 for lifetime membership, so just one time. And we have classes on Mondays and Fridays on Zoom, so that works for me. Yeah, taxes is a big thing right there. I'm starting to see why, with more of what we just discussed tonight, why it's all taxation. Yup. There's a lot that goes into it, but it's really, like, this stuff isn't that hard. It's just a lot of small moving pieces. And if you understand, like, the moving small pieces, it makes the entire picture a lot easier to decipher. So, you study the foundational principles and you'll see it. Any other questions? Those are two different doctrines. One last lady. Conveyancing is the law, or is the process by which possession is passed. Season is possession. Livery, is also dealing with possession. So, when something was seized, that means they've taken property of it. When something is disseized, that means somebody has lost possession of it. So conversion is when one thing changes nature and from one thing to another, either in form or in substance. That's conversion. So conveyancing is different. They're two different actions. Yep. Yeah, so I know we'll have a few things to talk about tomorrow on the workshop. I know that we'll have a few different things. So everyone, read the Geneva Conventions of 1949 for the amelioration of the sick and wounded, of armed forces in the field, shipwrecked persons, and the convention relative to the treatment of prisoners of war. Those are very key conventions, key in international law, and they do matter, very much so. Yep. Well, I'm grateful for everyone that stayed on. I'm grateful for all the support that I've gotten thus far. I can't do it without, the people that I've, been around and has gotten me this far. It's been a huge help. I'm grateful for it all, and looking forward to getting this thing wrapped up. So it becomes clearer and clearer every day. So yeah. Well, y'all, like I said, I'm grateful for everyone being on tonight. Those that are in the workshop, I'll see y'all tomorrow. And yeah, all praises to the Most High. This is B with 2B Fruitful Training Group, and I'll see you on the next one. Y'all have a good night.